90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. As part of our continuing series about COVID and how it affects legal issues, we're pleased to welcome Michael Schmidt. He's an attorney and in the Labor and Employment Department with Cozen O'Connor, a large national law firm. Mike, welcome to Law You Should Know.
Ken, thanks so much for having me today.
Mike is a labor and employment attorney, and people having COVID or trying to return to work from COVID, return to work after suffering from COVID, what are some of the disability rights that employers may have to worry about in the workplace?
So one of the biggest things that employers need to be thinking about, number one, the legal obligations that they may have in terms of what accommodations they have to provide to employees from a legal perspective. But the second bucket, which may be just as important as the legal obligations, has to do with the psychology, all of this, and what will likely be the lingering psychology when it comes to employees being asked to return to the workplace, either now or in the next several weeks and months. And what I mean by that is you're distinguishing between employees who have a generalized fear or concern about leaving their homes, using mass transit, as opposed to employees who may have an underlying health condition or some form of disability that does, as a matter of law, require some accommodation.
Now, there's that fear of contracting COVID, of suffering further because of COVID, having a relapse. Does that itself create a psychological condition?
Well, typically, no. I mean, again, a generalized fear that you're going to contract it or a fear that you're going to bring it home to somebody that you live with who may be vulnerable, that in and of itself is not something typically protected by the law. But if you do have an underlying condition that may become exacerbated by COVID-19 or contracting it, then that might be something that triggers a responsibility to accommodate, or at least have an interactive dialogue about a possible accommodation.
Should the employer initiate a dialogue to learn those conditions, to have employees communicate those conditions, and also that if they do not hear anything, they'll assume the employee is physically and mentally A-OK and ready to come back to the office?
Yeah, it's a difficult situation. I have so many clients now who try to do the right thing. You know, they know that somebody may be of a certain age, over 65, or they may know either directly or indirectly that they have some sort of health condition, and they want to approach that individual and tell them, hey, we're not going to let you come into the office, thinking that they're doing the right thing. The problem is when an employer starts making assumptions or presumptions about an individual's ability to perform his or her job. So you are better off letting the employee come to you and approach you without having to use any legal buzzwords, but at least come to you and suggest that there is some need for a possible dialogue on an accommodation.
Is it also in the employee's best interest to get the worker to return to the workplace early and often to negate these other conditions or scenarios?
What do you mean? Is it in their interest?
Is there a danger if the employer continues to let the employee work from home and get used to that relationship?
Well, sure. There is an issue for those companies who traditionally have not favored teleworking and remote working. There certainly is that risk that going forward, to the extent that the individual was productive working from home, that it's going to be more difficult for a company to say, hey, we don't have to give you an accommodation of continued telework because we don't like it or we don't think it will work, when the evidence shows that for the past 5, 6, 7 months, it has worked well, if that's the case.
And what about the issue of productivity? Is it fair to hold that employee to the past standards of productivity, or should you expect them to be more productive because they're saving that commuting time and coffee break time?
I think it really depends on the individual. I know a lot of people who are working from home, and on the one hand, you can say, hey, they should be more productive because they don't have to commute. They may not even have to shower or walk more than 10 feet from their bedroom. On the other hand, a lot of individuals who are working from home are dealing with challenges of young kids who are homeschooled either completely or for partial weeks, and they're dealing with that or other type of obligations at home that make it more difficult to perhaps focus and be as productive as they would if they were in an actual office.
Can the employee use that as a crutch or an excuse if they have an elderly parent living with them, a spouse who may be at risk, or children who may be at risk, even if they are not at risk themselves?
Well, I don't know if excuse is the right word necessarily, but certainly there are particular laws out there. The primary one is the federal FFCRA, the Families First Coronavirus Response Act, which became effective on April 1st, and unless it's extended by Congress, will expire at the end of this calendar year in 2020. There are provisions that afford employees the right to certain paid leave if they don't have to just deal with their own conditions, but if they are, for example, taking care of somebody who has been diagnosed with COVID or who is required to themselves self-quarantine, employees may be entitled to certain leave rights in those situations.
How should the employer research these things or document it or tend to try to learn about it just so they're aware of the potential scenarios?
Sure. Well, if I really wanted to be completely self-serving, which you haven't asked me to do, I would tell you to listen to my podcast. I do an employment law podcast typically twice a month. It's called Employment Law Now. You can find it on iTunes, Spotify, everywhere you find podcasts, as well as at employmentlawnow.com. That's a good way of keeping abreast with things. But the other way is to use the value of the Internet. You have the Department of Labor, for example, the United States Department of Labor. You have the United States Department of Health, as well as the agencies on the New York state level, who put out a lot of guidance and a lot of materials and rules and interpretations of rules. So it would certainly be a good idea for employers and employees as well to Google or take a look at those websites where they have valuable information.
And we'll let you mention the podcast later in the program in case anyone missed it. And also listeners are invited to share this podcast, which can be found at nccradio.org, to listen to it again or to pass it on to someone they know. I just want to remind the listeners, you're listening to Law You Should Know on 90.3 WHPC in Garden City, Long Island, New York. And you can also hear any portions of this program and other shows on WHPC at our website, nccradio.org. What are some other things that you wish employers knew, your clients and potential clients, about dealing with COVID now and in the future?
Yeah, I think one of the biggest takeaways, and it's very much the same with all aspects of employment law, but very much specifically for COVID-19, you, as an employer, you really should avoid being knee-jerk in your reactions to things. There are statements, there are activities that you are going to see being engaged in by your employees that you may not like, you may not think it's a good idea. But before you go ahead and, as I said, be knee-jerk in your reaction to take some sort of adverse action against the employee, you really should step back and think to yourself and analyze with yourself, number one, is there some sort of law or regulation that protects the statements and the activity they're engaging in, number one? And number two, is there a legitimate business interest that you are protecting by engaging in or taking the adverse action against the employee? And are you doing it consistently with how you have dealt with similar situations before?
I'm sure as an employer or lawyer, you also help employers develop their employee manuals. Do they need to review their manuals? Do they need to add to those manuals for issues arising out of COVID?
They definitely do, and it's always a good idea for employers to look at their employee handbooks and manuals. We suggest at least once a year, but for situations like this, when you're talking about COVID-19 related laws, whether it's leave rights, whether it's accommodations, paid time off, things like that are specific to this particular pandemic, workplace rules. And we'll talk in a minute perhaps about social distancing and physical aspects of the workplace. To the extent that your workplace rules and standards of conduct are changing, even if temporarily, it is a good idea to revisit your handbooks and manuals and see what should be revised and updated.
And let's talk about the physical aspect of the office. Everyone's concerned about social distancing. How might this change requirements for what goes on at the office, even looking ahead to social functions or lack of, or company meetings internally or externally?
Well, we're seeing a lot of changes that we never thought would ever happen, certainly before February or March of this year. We're seeing a lot more use of video conferencing through Zoom, Microsoft Teams, all kinds of other platforms that may take away from a lot of the in-person gatherings in conference rooms, whether it's in kitchens, whether it's in conference rooms or other mass congregation areas. But you're also seeing a lot of changes when it comes to scheduling, how we are staggering employees who are coming into work, their leave time, their start time, and how we're spacing employees around the office so that you don't have significant numbers of people working at the same time and working closely in the same areas.
Does the employer also have an obligation to put up barriers around the office in addition to the distancing to take greater air purification and sanitation in the office?
Certainly among the things that they should be thinking about. New York State, the New York State Department of Health, as well as other local departments of health, have put guidance out there where you could find it on the websites that talk about things like air quality, air filtration systems, as well as, to your question, physical barriers, whether it's plexiglass between workstations, otherwise increasing the spacing between offices or work areas, and other things that offices and employers should think about doing to not only make the workspaces actually be safer, but to deal with what I said before is the psychology of all of this, and that is to make employees feel as if they're coming back to a safe and a healthy work environment so that they could be most productive and not worry as much about the quality of where they're working.
And what about moving around the office, away from someone's desk? Should there be a regulation concerning appropriate mask wearing?
Should be talking about the appropriate PPE, including masks. It may also depend on the type of office, the type of facility that we're talking about, given the nature of the work people are doing. Maybe that just requires masks. Maybe, depending on the nature of the work and the close proximity of individual workers, it may require other types of PPE. But you're also talking about signage and directional considerations. Should we have certain hallways and areas be for one-way travel as opposed to leaving it up to the workers themselves as to which direction they're going to work? And is that going to mean that, we're more likely going to be in close quarters with other individuals as we travel through the office?
And let's talk about reaching the office. If there's an if a person has to use on an elevator, that could be the weak spot in the workday. What can employers do to manage that and prevent spread of COVID in an elevator?
Well, it also a couple of things. Depending on who owns the building, if you are an employer and you are working in a building that is managed and or owned by another entity, you really should be in communication, if you haven't already been, with the landlord, with the building management, to talk about issues involving common areas such as the lobby of the building, such as elevators. And from the employer's own standpoint, things like staggered work times, both arrival and departure, will also help ease the number of people who are in elevators as well as standing in elevator banks waiting for the elevators.
In setting up those staggered work times, should they also consider the needs and the schedules of their workers? Perhaps they need to have a free period of the day for children, for themselves, for other things. Should the employer work with them on that?
No question. I mean, like everything that we're talking about, the best way that employers can avoid, if not just mitigate, problems is through open communication, open dialogue with the employees. So rather than simply, here is a list on the wall, this is when X group has to come in and Y group has to come in. It's always a good idea, whether it's an initial sign-up sheet or some other way of soliciting what start times, what end times, what break times might be best for the employees. And then if there's too much overlap or if the initial voluntary system doesn't work, then the employer can start to step in and work around that as much as possible. But as much as you are able as an employer to engage the employee in a lot of these conversations and decisions, it's going to solve a lot of problems and avoid a lot of problems.
And discussion and flexibility and dialogue and give and take are much better than onerous regulations.
Yeah, and I feel like I'm beating a dead horse when I talk about both the legal aspect of all this, but also the psychological aspect of this. There's no question that dialogue, interaction with the employees as much as possible is really going to make employees feel as if they have a stake in this and that they, after being asked to come into the workplace, are coming into one that is healthy and safe. Again, it's really being flexible and addressing the psychological impact of your returning employees, all while recognizing the rights that employers have to operate their businesses efficiently and productively.
What other issues do you see down the road arising out of COVID? We think we're going to be dealing with this for 6 months, 12 months, 18 months, or the after effect for a long time to come. What scenarios do you see?
Wow, I mean, it's already felt like we've been dealing with this for years. It's hard to believe.
And we all have fatigue.
We all have fatigue of all kinds. It's amazing that this started in 2020 and we're still in 2020. But you're right. There are going to be lingering impacts of this. There are going to be things that employers have to be thinking about well into 2021, and to your point, probably long after that. When it comes to the issues we're talking about, healthy and safe workplaces, potential discrimination claims that are arising out of COVID-19 and decisions that employers are making, action taken by employers against employees for saying and doing things that the company doesn't necessarily agree with, but are otherwise lawful. Wage and hour, compensation kinds of issues. How are we as employers being able to track time and ultimately correctly pay for time when employees are increasingly engaged in work outside of an office where the company doesn't get to see and monitor their working time? Those are among the issues that I think we're going to continue to grapple with as we deal with such a novel and unique set of circumstances.
And also going forward in interviewing people, whether it's a retail perspective or to work in an office, to work as an executive, can an employer ask questions about COVID fatigue or COVID concerns, or would that run afoul of various discrimination?
You want to be careful. Yeah, you want to be careful with that. Like any care that has to be taken during the recruiting process, even pre-pandemic, you want to be careful to stay away from the sort of typical protected class kinds of questions, whether it has to do with age, whether it has to do with familial obligations and status with your family or from a marital standpoint, issues having to do with underlying conditions or disabilities. I think the best thing that you can continue to do, even with COVID, is focus your recruiting and focus your interview questions on here is the job duties, here are the job requirements, here's what you will be expected to do. Do you have any issues or concerns with being able to perform those roles as we've laid them out for you?
I just want to remind the listeners that you're listening to Law You Should Know on 90.3 FM, the voice of Nassau Community College in Garden City, Long Island, New York. We're talking with labor attorney Michael Schmidt about COVID issues, especially for employers. And he is with the firm of Cozen O'Connor and part of their labor and employment department. And they're a nationwide law firm. And the information and advice he can give you can help you regardless of where in the country you are. So are employers consulting you about their long-range response to COVID and its aftermath?
Absolutely. We've been doing a lot of talking, and the good news is the communication started really early on back in March when the pandemic and the remote work from home requirements were really beginning. But the good news for employers, even if you have not started or did not start your planning that early, it's never too late. So to the extent that you want to not only be thinking about the plans for your employees to be returning to work, the plans for what is your workplace and your workplace policies going to look like into 2021, now is the best time to start doing that if you haven't already, while keeping in mind, and I think you used the word flexibility at the beginning of this discussion, keeping in mind that whatever plans you have and whatever plans you continue to update, you will need to have some measure of flexibility as we go through the next few months and maybe the next few years to adapt to an ever-changing situation.
So it's almost like a battle plan, and you're helping the generals to come up with their battle plan depending on the course of that COVID takes.
No question. I mean, we certainly do work with clients to represent employers in litigation once lawsuits have been filed. But a good bulk of the work that we do is exactly what you just said, helping them come up with their plans, not just to give them technical legal advice, but how do you apply existing legal rules, what legal rules may be forecasted to come down the road, how do you apply those to your particular business and your particular industry? That's something that we certainly do with our clients.
And also giving them a legal checkup so that they're ready to deal with COVID, whichever course it takes over the next year or two.
It's a legal checkup, and we get to be proactive when something comes up or when there's a new legal development. We get to reach out to our clients, but we also afford the clients the opportunity to give us a call or give us reach out by email if they want to bounce around an issue that they're thinking about or something that they haven't implemented yet, but they've heard from someone else, another company in the industry, and they want to bounce that around and talk strategically about whether it makes sense for their business.
Hey, tell us what other topics you've covered on your podcast and you intend to cover in the near future, and again, where our listeners can find your podcast.
Sure. Thanks so much, Ken. We talk about everything from hiring to firing and all things in between when it comes to employment law developments. We have had tremendous guests on the podcast, both from various industries, retail, financial services, transportation, public sector, to talk about things that are keeping them up at night. And we've also had the opportunity to bring in guests from the government sector. The head of the Federal National Labor Relations Board, the former commissioner of the federal EEOC, the New York State Department of Labor gave us a terrific representative to talk about retaliation issues that have been so prevalent under New York state law. So we continue to try to keep everybody abreast of what's happening in the world of HR and employment law issues, while at the same time trying to keep it somewhat entertaining. The name of the podcast is Employment Law Now. It is on my dedicated website, employmentlawnow.com, but you can find it, as I said, everywhere you find podcasts, whether that's Spotify, iTunes, Google Play. And if you need a further tease to go listen to this and subscribe, and it is a free podcast, by the way, I wrote and performed the theme song for my very own podcast. So if that doesn't get you to go listen to at least one episode, I don't know what will.
So you're not only a star as a lawyer, you're a rock star as well.
Well, I will let others decide whether star and rock star apply, but I appreciate it.
Okay. What other tips would you like to offer employers out there, or suggestions to workers themselves, just to help everyone get through this together?
Communication. That works both ways, from the employer side and from the employee side. I often tell people, clients in fact, that dealing with employers and employees and that relationship is very much like raising children. If you think that you're going to start imposing rules and start talking about values and judgment when the kids first become teenagers, you've already missed the boat. Instead, if you started out imposing good values, having an open dialogue, an open door policy with your kids right from the beginning, you're much more likely to have a healthier dialogue in the years to come. Very much the same when it comes to employers and employees. Don't wait until your employee has been there for 20 years to start imposing expectations. Don't wait to start having open and honest communications with your employees only when a crisis occurs. The more you start now talking with your employees, letting them feel as if they are engaged in things that matter to them and things that affect them in the workplace, even though they're not going to be able to dictate everything and anything when it comes to how you're operating the business. But the more you are able to have that open dialogue as a company, and the more you have developed a mindset as a company, that it's not just about the technical law, but it's about the psychology of your workforce. The more you do that from the beginning, I think you're going to avoid, if not at least decrease, the number of claims and the number of problems you have with your workforce.
And also how toxic they are to discuss and resolve these different issues.
No question about that. You'll be able to see that pretty early, too.
And we've been talking about offices, but any other thoughts in turning retail employees or manufacturing employees on how these issues can apply to them going forward?
Sure, and a lot of these do apply to that. I mean, we have been talking a lot about the office setting, but whether you are in a retail store or whether you are in a manufacturing facility, again, there are these general takeaways and general principles that we've been discussing. But when it comes to at least having to tailor your particular workplace to COVID-19 best practices, you do need to look at the nature of your facility and understand that there is no one-size-fits-all to the kinds of things we're talking about. What may work in an office setting when it comes to social distancing and PPE and other workplace rules may not be as applicable to a manufacturing plant or a retail store. So it's important to take what we've been talking about from a general standpoint and apply it to your particular workplace setting.
And you're available to help your clients do that with every type of employer they are.
Sure. We have experience across the spectrum of all different kinds of industries and different companies within the same industry. It's not confined to just one particular type of workplace or even to just an office type of workplace.
Okay, I would like to thank our guest, Michael Schmidt, who's a labor and employment attorney with Cozen O'Connor.
All right, thank you.
You've heard he also has the employmentlawnow.com podcast, and you can find much more information on this topic. And please join us next week at this same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College. And feel free to listen to this podcast or other podcasts about the law at nccradio.org.